Good morning, friends. On 19th October, a landmark judgment has been passed by the Honorable Supreme Court on denial of income tax exemption to certain class of charitable and educational institutions. I am Ashish Agarwal from Team NGOenabler and have brought before you the key pointers from the judgment. Since the expression advancement of objects for general public utility has not been clearly defined and a lot of ambiguity still prevails, under the guise of it, many charitable organizations were running trade or commercial activities on the grounds of predominant object being charitable as per the registered document. But now, with this judgment, the word solely in clause 6 of section 1023C has been clearly and explicitly defined by the Honorable Supreme Court to mean exclusively or only. I repeat, the word solely has been explicitly defined by the Honorable Supreme Court to mean exclusively or only. The judgments in all the earlier related cases were covered by the judgment, specifically that of American Hotel and Queen's Education Society, where the word solely was interpreted to be predominant or mainly, and has now been overruled to give it a new interpretation as assigned and confirmed by the bench of Supreme Court to be exclusively or only. Another set of appeals related to educational institutions earning profits was also heard by the same bench, where it was held that any educational institutions should exist only for imparting education or educational activities and not for any profit motive to be eligible for tax exemption under section 1023C. In the course of the judgment, what can be considered as the incidental activities to education is also covered, which includes bus facilities, hostel facilities, textbooks, etc., but only to the extent available to the students of the same institution and not outsiders. I repeat, in the course of the judgment, what can be considered as incidental activities to education is also covered, which includes bus facilities, hostel facilities, textbooks, etc., but only to the extent available to the students of the same institution and not for any outsider. This can be of a great relief to the organizations actually running such facilities for its students. Thus, it might seem that if any charitable organization imparting education have other objects as per the registered document apart from education or related activities, might no more be considered for approval of exemptions. But more clarity is required on this, as merely mentioning of the objects does not seem to be a challenge, but actually involving in any of such unrelated activities might lead to denial of exemption. However, to avoid disruption and give time to the educational institutions that might get affected because of this judgment, it has been made applicable prospectively from financial year 22-23 and not retrospectively. In a crux, it seems only those educational institutions which are operating wholly, exclusively, and only for the purpose of education and education-related activities as covered by the judgment and having no intention of profit motive shall be eligible for approval of exemption under section 1023C of the Income Tax Act. Involving in any unrelated activities to the extent it falls under the advancement of object for general public utility also seems to be allowed if no profits are earned. If any profit is earned out of such unrelated activities, the organization might have to keep separate books of accounts and might also end up losing any tax benefit. You can find the copy of entire judgment in the description box. The detailed analysis of the judgment shall follow soon. For more such updates, keep tuned to our YouTube channel and follow us on Instagram, Twitter, and Facebook. Thank you.